Welcome to Business Coordinators. Today we are looking at the case the Mussoorie Bank Limited versus Albert Charles Raynor. The citation of this case is I.L.R 4 or I.L.L 500. So let's look at the facts of the case. One Captain William Raynor died in 1860 December after having made a will in these words: I give my dearly beloved wife the whole property, both real and personal, feeling confident that she will act justly to our children in dividing the same when no longer required by her. He appointed his son William Joseph Raynor and his wife Mary Raynor to be his executioner. Mrs. Raynor alone provided the will. तो ये कैप्टन विलियम रेनॉर थे. इन्होंने दिसंबर 1980 में एक विल की, एक वसीयत की, जिसमें कि उन्होंने कहा कि मैं अपनी सारी चल व अचल संपत्ति अपनी बिलवेड वाइफ को दे रहा हूँ और मेरी वाइफ इसको डिवाइड करेगी मेरे बच्चों के बीच में जब उसको ज़रूरत नहीं होगी इस प्रॉपर्टी की. During her lifetime, no question arose as to the nature of the Captain Raynor's will. It appears that she possessed all of his property and she assumed to deal with it as though it was her own. तो मिसेस रेनॉर जो थी उन्होंने यूज़ की प्रॉपर्टी जैसे कि वो उनकी खुद की संपत्ति हो. On 5th September 1868, Mrs. Raynor, who is the respondent in this appeal, wrote with accordance to which she gave her son Albert Charles Raynor, who is the respondent in this appeal, 24 of her shares in Delhi and London Bank, and she also gave him a house and land. Other properties were given partly to her daughter and the said will. She died in 1875 and her will was provided. तो मिसेस रेनॉर जो थी 5 सितंबर 1968 को उन्होंने कुछ संपत्ति अपने बेटे के नाम की जिसका नाम था एल्बर्ट चार्ल्स रेनॉर और कुछ शेयर्स दिल्ली और लंदन बैंक में थे जो उन्होंने अपनी बेटियों के नाम की थी. वो 1975 में मिसेस रेनॉर की डेथ हो गई. In 1976, the Mussoorie Bank, who was the appellant, instituted two suits against Mrs. Raynor, executioner, for the purpose of recovering sum of rupees 25,000 advanced by the banks to Mrs. Raynor upon the security of 30 Delhi Bank shares and of certain houses. तो Mrs. Raynor को कुछ पैसा देना था बैंक को, 25,000 rupees. One of these suits, number 41 1876, was instituted in small cause at Dehradun on 5/12/1876. The bank obtained the money decree under which 30 shares were attached, and the other suit, number 115 1876, instituted before the subordinate judge Dehradun, was to enforce bank's mortgages upon the house. तो ये बैंक ने डिस्प्यूट किया, कुछ शेयर्स थे और कुछ बैंक मॉर्गेजेस थे, वो उनको कंसिडरेशन में लिया गया. On 12/12/1876, the bank obtained the money decree by the subordinate judge, refused to give them any specific relief on base of the mortgage. Against this judgment, the bank appealed in the High Court. तो बैंक को कुछ नहीं दिया अपील्स कोर्ट ने, तो यह बैंक हाई कोर्ट चला गया. When the appeal in the mortgage suit was pending, Albert Ryan brought the present suit for the purpose of setting aside the order of the 5th December 1876 so far as regard 24 bank shares bequeathed by to him by his mother and for obtaining the possession of those. The case may be made by Albert Raynor. Respondent is that Mrs. Raynor took only a life interest in her husband's property. तो ये कहा गया कि मिसेस रेनॉर जो थी उन्होंने सिर्फ अपने हस्बैंड की प्रॉपर्टी में शेयर लिया था. By its judgment dated 10/5/1878, the subordinate judge dismissed the suit on the grounds that Mrs. Raynor took an absolute interest under her husband's will. Albert Raynor appealed to the High Court, and the High Court decreed the suit on the ground that Mrs. Raynor held her husband's estates not absolutely her own but as the trustees of their children, with the power of dividing amongst them. The bank then applied to the High Court for leave to appeal against this decree on 13/10/1878. The High Court refused to grant leave on the ground that the property at stake in this suit was valued for more than 6,000 rupees, and that the question of law was so clear that an appeal could not only result in the affirmation of the justice. The bank then presented a petition to Her Majesty in Council to leave to the appeal, and the leave was granted. One more point that is remaining in this case is the primary objection was taken by the respondents in leave to appeal. Respondents' counsel contended that the fact in their petition is so framed is to mislead the court. To bring in his favor decision on false grounds, their lordships, after discussion, rejected the preliminary objection raised by the respondent. तो ये भी कहा गया कि भाई ये कोर्ट को कंफ्यूज करने के लिए मैटर लाया गया है कि माँ का प्रॉपर्टी थी कि बेटी की प्रॉपर्टी थी. Passing to the merits of the case, their lordships were of the opinion that the current decision, now prevalent for many years in the Court of Chancery, shows that the doctrine of trust is not to be extended. It is sufficient that the purpose to refer to the judge given by the judge Justice James in case of Lame versus Evain. They were further of the opinion that the doctrine of precursory trust were applied to present case. It would be extended far beyond the limits to which previous cases have gone. No cases have been cited, and probably no cases would be cited, in which the doctrine of precursory trust has been held to prevail when the property said to be given over is only given when no longer is required by the first taker. Now the rules are very clear with the respect of doctrine of precursory trust, that the words of the gift used by the tester must be such that the court finds them to be imperative on the first taker of the property, and that the subject of the gift must be well defined and certain. In this case, nothing is given over to the children of the tester except by expression of confidence in his wife that she will deal with justly dividing the property among them, and that she will do it when the property is no longer required by her. तो ये कहा गया कि भाई जब वाइफ के काम की नहीं होगी प्रॉपर्टी तब वो इवनली डिस्ट्रीब्यूट करेगी अपने चिल्ड्रन को. The lordship thought that substantially the words when no longer required by her must in this will be taken to have the same meaning as if he said, I give to my children so much as not required by her, that is equivalent to the absolute gift to the wife. The lordships also did not thought over the various cited by the counsel of the respondent Respondent, as they considered it sufficient to say that upon this the wife took an absolute interest, and then the doctrine of uh, precautionary trust to it would be a very large extension of that doctrine. Judgment. The appeal was allowed the decree, and the judgment of the High Court was reversed, resulting in the dismissal of the plaintiffs.
So let's look at the principles of law laid down. In order to create a precatory trust, the words must be such that the courts find them to be imperative on the first taker of the property, and the subject of the gift must be well defined and certain. मतलब जो शब्दों का प्रयोग किया जा रहा है विल में वो एकदम क्लियर होने चाहिए उस ताकि जो भी व्यक्ति जिसको भी फर्स्ट प्रॉपर्टी मिल रही है उसको कोई प्रॉब्लम फेस ना हो। तो एकदम क्लियर टर्म्स में होना चाहिए कि ये क्या बोला जा रहा है। Precatory words like request and are not imperative and do not create a trust. तो रिक्वेस्ट जैसा शब्द यूज़ नहीं करना चाहिए। Where there is an absolute guilt by one person coupled with a recommendation that shall be to a certain request a certain other person, so much of it as may not be required by her, it will be equivalent to absolute gift in her favor without certain of any trust in favor of any other person. तो अगर उनको कोई विल करनी थी तो एक एब्सोल्यूट टर्म्स में करनी चाहिए थी कि मैं अपनी वाइफ को ये प्रॉपर्टी दे रहा हूँ और किसी और व्यक्ति को इन्वॉल्व आइडियली नहीं करना चाहिए था। So thank you for watching this video, and we'll come up with more videos in future.